Hello and welcome to this session in which we will discuss the 4 types of warranties, including the perfect tender under the Uniform Commercial Code UCC. Remember, the Uniform Commercial Code is the sales of movable goods. We have this important concept that we said perfect tender. What is a perfect tender? Perfect tender means you should get what you ask for. Why? Because under the UCC, you are buying goods. And goods, when you buy goods, you should meet your specification. For example, if you purchase something online from Amazon or from some other online service, you're going to see the description, you're going to see a picture of it, you're going to see how it works. You would expect to receive what you get. Now, when it comes to a service, remember service under common law. When someone performs a service, the service may not be a perfect tender because in a service, the person is using their skills, their professional judgment. So you may not receive a perfect service, but you would expect to receive, in quote, a perfect tender for the sale of goods. Now, exactly what do we mean by perfect tender? Well, you have to get the exact conformance to contract. It means what? The goods delivered to you must be exactly as described in the contract. This includes the types, the quantity, the quality, and any other specified details. There should be no defects. The goods must be free from any defects. When you buy something, the assumption is you're buying something new. It has no defects. It means it should be in perfect condition at the time of delivery. Also, it has to adhere to warranties. What are warranties? Warranties are promises or guarantees about the condition, quality, or performance of the goods. So goods must meet any or all warranties provided. Now, specifically, we're going to be discussing 4 types of warranties in this session, and this is what this session is all about. So this is how the type of warranties fits into this session through the perfect tender. Also, the buyer's right to reject. If the goods do not meet these standards, what can the buyer do? Reject, refuse to accept them. This is because the seller did not meet the requirement of the perfect tender. So what we're going to be discussing specifically are the 4 types of warranties. Let's go ahead and get started. Before we proceed any further, I have a public announcement about my company, farhatlectures.com.
Farhat Accounting Lectures is a supplemental educational tool that's going to help you with your CPA exam preparation as well as your accounting courses. My CPA material is aligned with your CPA review course such as Becker, Roger, Wiley, Gleam, Miles. My accounting courses are aligned with your accounting courses, broken down by chapter and topics. My resources consist of lectures, multiple choice questions, true-false questions, as well as exercises. Go ahead, start your free trial today.
The 4 types of warranties are express warranties, implied warranty of title, the implied warranty of merchantability, and the implied warranty of fitness for a particular purpose. And as you know, if you know anything about Farhat Lectures, once I have a list, what do? I'm going to go over each item on this list separately. I'm going to explain it, provide an example, give you a summary, then we'll work a multiple choice question. Express warranties. Well, I'm expressing. It's created when the seller makes specific promises. I'm expressing myself. When they explain the description, presentation about the goods being sold, and this includes statement of facts or promises. Any factual claim or promise about the product made by the seller is an express warranty. Description of the goods, detailed description provided by the seller. Those are examples of express warranties. If the seller provides you with the sample, here we go, take a look at this, use it for a week or so, and make sure you're comfortable with it. Well, samples or model, if the seller shows a sample or model of the product, those are called express warranties. The key point of express warranties is that the actual product must match these representations. So if you showed me a sample, you can't go back and sell me something else. Or if you have a description of the product, you cannot change the product that you promised me. Express warranties can be given by any seller. And when we say any seller, it means merchant and non-merchant. I hope you know what a merchant is versus non-merchant. Not just those who are officially merchant. They can be also in oral form or written form. However, expression of value or opinion, those are not express warranties. For example, your opinion about the product is not a warranty. Let's look at an example. Let's assume a seller advertising a laptop as having 16 GB of RAM and a high-speed processor. Well, this statement creates an express warranty that the laptop indeed will have the 16 GB of RAM and a high-speed processor. Those are factual claims. However, if the seller state that the laptop is best for gaming, this does not create an express warranty because it's a subjective opinion, not a fact. So the express warranty only applies to the clear, factual statements of the seller's claim, not their opinion. Now, can this express warranty be disclaimed? In other words, I'm going to give you the statement that, you know what, I really cannot stand behind. You cannot disclaim express warranties because they're giving you the description, the factual fact about the product. They cannot be disclaimed. Let's talk about implied warranty of title. What is that? That's a legal assurance that is automatically included in the sales of goods. This warranty entails several guarantees from the seller. So when you buy something, there are certain implied. They don't have to mention them. They're usually implied. Good title. What's a good title? It means the seller guarantee they legally own the goods and have the right to sell them. No hidden encumbrances. What does that mean? The seller assures you that there are no hidden liens or debt against the item, against the car that you are purchasing, against the goods that you are purchasing. There are no encumbrances, liens or debt. Why? Because if you purchase an asset and it has a lien or a debt, then you are responsible for that lien. If there's a loan against that car and you purchase the car, you have the title, well, you're carrying the loan as well. Also, we have an implied of no patent or trademark infringement. This implied warranty applies to merchant only. They also implicitly assure that the goods do not violate any third-party intellectual property like patent or trademark. Now, bear in mind, this implied warranty can be nullified if the seller uses specific language indicating that they are not guaranteeing their ownership of the goods. What does that mean? They can tell you, look, you are buying this, but we cannot guarantee the ownership of the goods. And this might occur in certain situations like a court sale, a judicial sale, because what happened is this: when you purchase a home in a court sale, because the government just want their money, they don't care if the place has a lien or an encumbrance on it. You buy the house. If there's any loan against it, then guess what? You have the loan. However, general disclaimer like sold as is with all fault or broad warranty disclaimer do not override the implied warranty of the title. So you cannot just say, sold as is with all fault or any broad disclaimer and say, I'm off the hook. They don't override this implied warranty of title. So when you sell something, there's an implied warranty of the title. Unless it can be nullified if the seller uses specific language that they're saying they are not guaranteeing it. And no one's going to sell you. Actually, you will not buy something when the seller says, look, I'm selling it to you, but I don't really own it. Would you purchase something like this? Well, again, judicial sales like court sales, those are special because you're buying it at a deep, deep discount and you're taking that chance. There are no liens or encumbrances. If you want to take that chance, that's your call. Example, consider a scenario where you buy a used car from a dealer. Without explicitly saying so, the dealer is guaranteeing that they have the legal right to sell the car, what's called the good title. There are no undisclosed loans or liens against the car. There's no hidden encumbrances because if you purchase that car and you have a clean title, you also have the loans, and the car does not infringe on a third-party intellectual property. If the dealer wanted to disclaim this warranty, they could not do so with a general statement like sold as is. Instead, they would need to use a specific language clearly stating that they are not guaranteeing that they legally own the car, and most likely they're not going to get the sale if that's the case. So it cannot be easily disclaimed. That's the point. They have to be very specific, and the person on the other side should understand, they don't have legal ownership. Third warranty is the implied warranty of merchantability. In a transaction involving merchant who specialize in the kind of goods being sold, there's an automatic warranty as the implied warranty of merchantability. And what does that mean? It means the goods are assumed to be suitable for their intended purpose, whatever their intended purpose is. This warranty does not require any verbal or written communication. If you buy a computer, you would expect when you turn it on to come up, if you're using Windows, to be able to use the Windows, you be able to use word processors, your Excel, browse the web, be able to download application. That's implied, because a computer is supposed to work as a computer. It does not matter whether the buyer is a merchant or not. That is an implied warranty of merchantability. It doesn't matter if you are a merchant or a regular person. You would expect the asset, the item, to work as expected. Now, disclaiming the warranty, a seller can opt out of this warranty by explicitly stating that the goods are sold as is. As is means, look, you're buying this computer. I don't know, when you turn it on, if it's going to work or not, I can't tell you. But they have to say it's as is, with all fault. It means it might have a virus. Okay. However, to specifically disclaim merchantability, the seller must use the term merchantability. The merchant must use this. So general disclaimer, like we disclaim all warranties, won't suffice. The disclaimer can be verbal, but if written, it must be promptly displayed to catch the buyer's attention. So if you write it on the computer box, you want to make sure they see it, that you're buying this as is. Like sometimes if you go to Best Buy, what they do sometimes, they sell their laptops that was for displayed, because people were using it a lot. It might have some defect. So what they do when they sell it, they will tell you, we're selling it as is. It means it should be working, but if it doesn't work, you bought it. It's yours. Example. Let's assume you are buying a refrigerator from a store that specializes in home appliances. It's a merchant in this context. Without explicitly saying so, you would assume that the refrigerator does what? Keep food cold. That's an implied warranty. If the store wants to sell this refrigerator without this warranty, they will need to clearly state that it's being sold as is. And sometimes at Home Depot, they do that. Refrigerator that they have at this as a display, sometimes they sell it as is. They sell it at a deep discount, and many people take their chances. I know a person that does this. They go to different Home Depot and wait until they have those items as is and buy them. And sometimes it works and sometimes it does not. We disclaim the warranty of merchantability. If this disclaimer is written, it must be in a way that's easy to notice, like bold or larger font. Then we have an implied warranty of fitness for a particular purpose. Now, it's not about this fitness. It's about the use for a particular purpose. The implied warranty of fitness for a particular purpose comes into play when the buyer depends on the seller expertise to choose goods that fit a specific need. Here you went to the seller and you told them, look, this is what I need to do. I need something that's going to serve my purpose. Is this going to serve my purpose? So the seller aware of your need. This warranty applies regardless of whether the seller is a merchant or not. So if you buy it from a store or you buy it from your neighbor. The two key conditions must be met for this warranty to be effective is what? One is the seller is aware of your need. So you have to express yourself. The seller must be aware of the buyer's particular need or purpose. And the buyer is relying on the seller's judgment to select the appropriate goods. Both of these has to be there. This is different from the implied warranty of merchantability, which assure you that the goods are fit for a general ordinary purpose. So if you want a particular computer with a particular processors for a particular purpose, like graphic design or programming, then you have to let the seller know and you have to rely on their judgment. Remember, the warranty of fitness is about suitability for a specific buyer-stated purpose and can be implied in any sale, not just those involving merchants. So it doesn't have to be a merchant, because it looks like, wow, it's warranty of fitness for a particular purpose. Well, your neighbor might know what that particular purpose is. It doesn't have to be a merchant. Example. Let's take a look at this scenario. Julia goes to a computer shop to buy a laptop. She tells the salesperson she needs a laptop primarily for graphic design work, which require high processing power and advanced graphic capabilities. What did Julia did? Express her need. Now the salesperson is aware of it. The salesperson recommend a particular model based on this requirement. We assume here that the salesperson know what they're talking about. In this situation, there's an implied warranty that the laptop is suitable for the specific purpose of graphic design work. If the laptop fails to meet those specific needs, despite being fine for general use, it would breach the implied warranty of fitness for this particular purpose. Let's look at another example where we disclaim. Emily goes to a garden store to buy a lawnmower. She explains to the store that she needs a mower that can handle her large, uneven lawn with a lot of thick, tough grass. The owner recommends a particular model, assuring her that's perfect for such condition. However, the owner also wants to disclaim the implied warranty of fitness for a particular purpose. To do this effectively, the owner could do what? Sell the lawnmower as is. By explicitly selling the mower as is, or with all fault, the owner would indicate that no specific fitness for Emily's particular purpose is being guaranteed. Or they could use clear written disclaimer. If the owner doesn't sell the owner as is, they could still disclaim the warranty by including a written statement in the sales contract that I make no warranties beyond the face of this contract. The disclaimer must be clearly noticeable so Emily sees it, perhaps in bold or highlighted text, to ensure that Emily is aware of it. In either case, if Emily buys the lawnmower under these conditions and later find out it doesn't work well on her tough, uneven lawn, she has no recourse against the store for breach of the implied warranty of fitness because the owner effectively disclaimed this warranty. Key points to remember. Disclaiming implied warranty or implied warranty can be disclaimed by using specific wording applicable even for merchant. You could always disclaim, but you have to use specific language. Implied warranties do not require written statement. They're implied. That's their thing. They're implied. They are automatically included in the sale contract, but they can be disclaimed using specific wording. Remember the difference between merchantability and fitness. Merchantability is the warranty is only provided by merchant and guaranteed good are fit for the general and ordinary use, nothing in particular. The fitness one, it could come from any seller, your neighbor or your next door store, your best electronic store. It applies when the buyer relies on the seller expertise to select goods for a specific purpose and ensures that the goods are fit for that particular purpose. Quick summary about the warranties. Express warranties, those are description, model, or sample, can be made by any seller, but they cannot be disclaimed. Because if you disclaim them, it means you're telling me this, then he said, I don't stand behind it. You can't disclaim express warranties. Implied warranties are clean title, no liens, no encumbrances. They can be made by any seller. They can be disclaimed by specific language or showing the seller don't have title. Implied warranty of merchantability, this applies only to merchant. Again, it can be disclaimed using merchantability or clear language. Actually, not or, clear language, but they have to use the word merchantability. Implied warranty for fitness for a particular purpose. Any seller that seller that knows the need of the buyer and knows that the buyer is relying on its suitability. This is where it arises. It can be disclaimed using clear language. Remember Emily? Well, we told her, the lawnmower cannot be used for her purpose. Let's take a look at this multiple choice questions from farhatlectures.com. Which statement is true regarding express warranties? So it's only one true and three are not true. Now it's easy since three are not true. Let's start with those three statements. They can only be made by a written statement. No, express, they can be oral or they can be written. So D is out. They are created by the seller's factual statements about the good. Is this what express warranties are? Are they about factual statement about the goods? This sounds good. This sounds like a good answer because express warranties are the seller's factual statement. So let's keep C. They arise from the seller's opinion about the goods. Is it opinion or is it factual? I would say factual. Opinion is out because opinions are opinions. Everyone have them. They can be disclaimed by the seller using general language. You cannot disclaim an express warranty. If you're telling me a factual statement, you cannot turn around and say, here's my factual statement, but I'm going to disclaim it. It's not really true. You can't rely on it. You can't do that. Express warranties cannot be disclaimed. A is out. Therefore, the answer is C. What should you do now? You want to go to Farhat Lectures. Look at additional MCQs. That's going to help you understand this concept better. The warranties under UCC. Very important concept, whether you're studying for your CPA exam, taking a business law course. Good luck, study hard, and of course, Stay safe. Farhat is always here to help.